Good morning, Judge. Is it still morning? No, it's
Nope,
noon already.
we went over. All right, get it. Good one. This is, I think, plaintiff's emergency motion, correct?
I believe we might have docketed something. It doesn't appear as though
With final settlement and so, um, I should let you know that I received a email this morning from Miss Lyman. And she's at U of M Hospital, not being able to make court today. And she has her tag on. So that's the first thing. The other issue was, I believe, Miss Anderson had sent to the court based upon, I guess, the inspection or whatever, that what looked like red tags on the door to the premises.
Yeah, my understanding is she's been very prolific in sending proof to the court. And I've cautioned her to have that entered as evidence when it comes to trial. That would be my preference. But as far as the Miss Lyman's non-appearance without formal pleadings being filed or contacting me with news that she's in the hospital, I find that kind of suspect. I would ask that default.
Well, let me just say this. Attached is her admissions tag, but I don't have the date of it. It's around her wrist, but I don't have the date of admission.
Your Honor, my client has heard nothing. I have heard nothing. My client has begged and pleaded for admission to the house so she can assess the damage. She's been refused at every turn. It's high time that we get on with our lives here. I would argue that she hasn't exhibited cause for being absent at today's date with no formal papers filed with court, no contact to plaintiff's counsel or the plaintiff.
It seems to me that I'll give some deference to the fact that she sent the tag in, but the other, I think, problem in this case is that we contacted, based upon the tag command, we contacted Pittsfield. They have indicated that the house is unfit for human occupancy.
If I may interject, that wasn't the problem or the case when Miss Lyman took possession. I've been told that there are holes in the wall, many holes in the wall, more than you can count. Who knows what's going on with the plumbing or the electricity? And both of those are going to cause Pittsfield Township to take notice. I've seen tenants destroy property, and it appears as though this tenant is trying to destroy the property for whatever reason.
Yeah, I'm not prepared necessarily to make that because there was a list given, but not to us, of from Pittsfield. There is what was it? I believe my staff told me a September 14th check-in to determine what repairs had been done with Pittsfield. And I think they were going to check in with Miss Anderson. That they said September 14th. Again, that may be just for them a calendaring thing to try to determine what repairs have been done and do you want another inspection, which is typically how they would work. So I don't know that the September 14th date means much in any event. Uh, so here's what I'm going to do, because we specifically asked, because it was red tagged, whether it was condemned. It was we were informed that they don't use that terminology. So I don't know. I'm not sure what to make of what they're saying. Um,
So whatever the verbiage is, maybe it's not condemned, maybe it means the same thing.
it well, right. I kind of thought, sometimes in this world we want to say something, but everybody thinks that that's a bad word, so we make up a new phrase for whatever. And I get that. So what I think I'm going to do is this. I'm going to kind of split the baby here, where I won't. I'm not going to give a judgment or do anything today because she's not here. I think at least has sent the thing in saying she can't be here.
Oh, Your Honor, excuse me again.
I'm Go ahead.
I was told that she hasn't paid escrow for August, and we're into August now.
Right. She has not. But the only thing that would entitle you to is an immediate trial for possession. I think it's going to be, I think it's going to be the long and short of it happening in different ways. What time is the miscellaneous block on Friday? Three.
Yes.
All right. So I'm going to adjourn these out to this Friday at 3
Very good.
person. And at that point, be prepared to do something. I should have, if she can't be here or whatever, I'm just going to make my ruling on what's there.
Very good.
Okay.
Thank you very much, Your Honor.
Thank you.
Thank you. All right. Go ahead, Cal. Your Honor, Ashley Dolinsky on behalf of petitioner Ruth Fisher.
Your name?
Ruth Fisher.
All right. This is your petition. So go ahead, Cal.
Would you like me to start by voir direing her? Would you like me to speak on her behalf? What would you prefer?
You could speak on her behalf.
Okay. Okay, Your Honor, this is Ms. Ruth Fisher. Ms. Fisher is asking you today to please set aside 4 misdemeanor convictions: retail fraud in the 3rd degree, purchase of alcohol by a minor, operating while impaired, and operating while license was suspended. Ms. Fisher accepts full responsibility for the mistakes that brought her before the court. Does not minimize or excuse her past. Looking back, she recognizes that alcohol had a much greater hold on her life than she understood at the time. Several years after the conviction before the court, she reached a turning point after serving jail time while pregnant on a later alcohol-related offense. She realized that she was on a path that would cost her everything that mattered, and she made a decision to change her life. She followed through on that commitment. She participated in outpatient treatment services through Home of New Vision. She separated herself from the people that fueled her addiction, and she remained continuously sober since May 2017. She's also fully complying with every requirement of Michigan's driver's license restoration process, including the use of an ignition interlock device. Today, Ms. Fisher has been steadily employed by Trinity Health for the past 3 years as a medical assistant in workplace health. She and her fiance have been together for 13 years and are raising 2 children, ages 7 and 8, who attend STEAM school in Ann Arbor. They've built a stable home, strong family relationships, a supportive community in the Arrowwood neighborhood. Despite those accomplishments, this conviction continues to hold her back. She cannot attend nursing school and continue advancing her career in healthcare, and she cannot volunteer at her children's school. She's not asking the court to erase her past. And she's asking for the opportunity to have her record reflect the person that she spent the last 9 years becoming. So the purpose of expungement statute is to recognize rehabilitation when it has truly occurred. Ms. Fisher's actions demonstrate that rehabilitation. She's maintained nearly a decade of sobriety, stable employment, a loving family, and a commitment to living responsibly. For those reasons, we respectfully ask the court to grant her application today.
What do you have to say for yourself? Did I send you to jail?
Yes.
Yeah, I did. I know.
Yes.
And what did that mean to you? Why do you think I sent you to jail?
Oh, because of what I did.
Did you think you deserved it?
At the time, I probably did. Yeah.
Yeah.
Mm-hmm.
Not a good experience, right?
No, not at all.
All right. So what else are you doing with yourself?
Just busy being a mother, working.
Just being a mother. Okay.
That's
For all moms out there,
That's a lot.
okay. And you want to go to nursing school?
Yes.
Where?
I think Washington.
Over at the community college?
Mm-hmm.
Tell you a little secret about that program.
Mm-hmm.
My dad was a counselor at Washington
Okay.
way back a long time ago. And when the nursing program first started there, he was a counselor assigned to the nursing program. So I have a great attachment because I also teach over there.
Oh, nice.
And my mom was over there. And I have a great attachment for the nurses that go through that program because it's a good program.
Mm-hmm.
So this holds you back. You also can't volunteer at your kid's school.
Mm-hmm.
That's gonna hurt.
Yeah.
Yeah.
Mm.
All right. Anything else you?
We're now at a major turning point in this hearing. After years of mistakes, Fisher is standing before the same court asking for a second chance, and the judge is clearly looking beyond the old convictions to see who she has become. Nearly a decade of sobriety, steady employment, a family, and a genuine goal of entering nursing school all paint a very different picture. But the judge still has to decide one crucial question: has she truly earned the opportunity to move forward?
Sorry, I don't know.
You're nervous right now, right?
Yes, I am.
Every time
I
before you
haven't done this
run
in a while.
some of it didn't go real well.
No, I didn't.
But anything else you want to tell me? No.
I've learned a lot from my mistakes, and I will not do this again.
You think about it though, isn't that what life's really about?
It is. Yes.
Mistakes.
Mm-hmm.
The important thing is not to repeat them,
Correct. Yeah.
right? And you're a different person now.
Oh, yeah. What is different? Yeah.
Court having read the petition and having heard the allocution of counsel, as well as the defendant, the court, and an opportunity for the attorney general and the prosecuting attorney to contest this application. There being no contesting of this application, court does believe, based upon the allocution, that the circumstances and behavior of the applicant from the date of the conviction cases to the application do warrant setting aside the convictions and is consistent with justice and the public welfare. Therefore, the petition to set aside the convictions is granted in all of the cases.
Thank you.
You're welcome. Good luck to you.
Thank you.
Thank you, Your Honor.
Thank you. First is Christopher Gill.
Your Honor.
Good afternoon, Your Honor. Adam Greer with and on behalf of Mr. Seated to my right. Good afternoon, Your Honor.
Good afternoon, Mr. Gill. Can you just state your name? Thank you. You know how. I'm dismissed. All right, what are we doing?
This time people will be unable to proceed as to count one, would ask for us to end on count two industry.
You're moving. Go ahead.
Certainly, Your Honor. I mean, at this stage, I don't believe we can object to the misdemeanor moving forward. I do understand and have counseled my client in terms of what a dismissal without prejudice would mean as it relates to count one. Certainly, we would support the dismissal of that count.
You're moving to dismiss count one.
I believe that's what the prosecutor moved for.
No. Prosecutor indicated they're unable to proceed as to count one. You would make a motion to dismiss count one.
We move to dismiss count one here.
All right. I'll grant that motion to dismiss count one. I'll continue the defendant's not guilty plea as to count two. I'll set pretrial
August 13th at 9 a.m.
August 13th, 2026, 9 a.m. before Judge Barr. Is that who you have? Yes, Judge Barr.
If I may address bond, Your Honor.
Yes, you may.
All right, I believe the magistrate set a bond in accordance with the severity of the felony offense. Certainly, my client has already had another misdemeanor case. I would ask that the court impose a bond in this case along with fines.
Well, I don't know what that is. You said he's got another bond in a misdemeanor.
That's correct.
So what is that?
$100 bond, Your Honor. It was going to start.
Where's that one at?
14A2 also.
At 2? Got it. Okay. So that was set so he get credit while he's on this one. Okay. Response?
Yes. Mr. Gilmore has a very extensive, including multiple RNOs along with 2 previous dismissed home invasion first in 80 seconds from last year with the same victim. So I do have to give this history and pattern of home invasions and DVs with this statement. I'll be asking that bond continue in this case.
Obviously there's a prior conviction for domestic.
Correct, Your Honor. In December of last year, involving 2 separate home invasion first DV second cases with the same victim that made it up to the court before Judge Collins, where they were ultimately dismissed by the people.
In response, I've just outlined this incident is not those. During this incident, my client did in fact call 911 himself. He understands that the relationship that he had not healthy and would not oppose any sort of no contact or even just be opposed to ensure that that no contact then is enforced. It's my understanding my client doesn't want anything to do with this individual anymore. As the prosecutor mentioned, he spent nearly 6 months in jail last year awaiting trial on that case that did not move forward. For that reason, I don't believe he should be continued to be held. Another case which likely to have the same outcome. So we would ask for the bond to be reduced in line with the retail fraud case, Your Honor.
And Your Honor, I may note for the record, in that case last year, there were multiple things not on the people's behalf, but on a previous attorney's behalf that kept Mr. Gilmore in jail. People at that last case were willing to stipulate to him being released prior to that dismissal due to the concerns of people that was not or that stip was not promptly or a plan also was not given to the people. And that is what caused Mr. Gilmore to be held longer than anticipated in that case. I just wanted to put that on the record.
All right. I'll modify the defendant's bond not to the extent that the defendant wishes, but he's set right now with a $25,000 cash surety. I'll lower that to a $10,000 cash surety bond. All right. All conditions remain in effect. All right. Thank you. Good luck, Mr. Gilmore. Well, Judge Barr, listen, Judge Barr can take a look at it once it gets over there because he's got your other case. So he may do something else once it gets there.
Thank you.
All right. You're all set.
Thank you, Your Honor.
Thank you.
And that brings us to the end of this courtroom session. We saw 2 very different outcomes today. One case was delayed because the judge wanted more information, while another defendant received a significant bond reduction. But the biggest takeaway is that courtroom decisions aren't always about winning or losing, they're about evidence, history, credibility, and what the judge believes is fair under the circumstances. What do you think about the judge's decisions today? Let us know in the comments, and if you enjoy real courtroom breakdowns like this, make sure you stay tuned for the next case.